Yes, Mr. Myers.
May it please you, my lords, my lady, Miss Clancy and I appear on behalf of Lucy Letby, who applies for leave to appeal against conviction for an offence of attempted murder returned by jury after trial on the 2nd of July this year before Mr. Justice Goss at the Crown Court at Manchester. And the respondent is represented by my learned friends Mr. Johnson, King's Counsel, and Mr. Driver, as they were at trial.
Yes.
My lord, as the court...
So, not so you understand, but so Ms. Letby understands, and indeed anybody else who's listening, we've had the opportunity to read well into the papers. We've been helped by your very detailed grounds of appeal and Mr. Johnson's respondent's notice. And it hardly needs saying that this case is very well known to probably most people in the country. So the background to it you can deal with in very short order.
I'm grateful, my lord.
And I think I should also say now, and will say again, this case has a very narrow focus today. The underlying convictions that were sustained last year and all the public discussion there's been more recently about them has nothing to do with what we're talking about today. You're simply here in relation to a single application you made and Mr. Justice Goss's refusal of it.
My lord, respectfully, that's correct, and that's exactly how we propose to deal with it.
Yeah.
And whilst I have, as counsel inevitably does have, a plan of the matters to go through, we shall, of course, respond to the court if the court finds I'm dealing with matters that are unnecessary or prolix. I hope to avoid that, but I appreciate the position of the court.
You take your own course, Mr. Myers.
So I shall follow the court's guidance on that.
Yeah.
It's important, perhaps, that I do set out the ground of appeal. As your lordship has identified, it is narrow. And it's this, that the learned judge was wrong to reject the application made by the defence at the outset of the trial to stay the indictment as an abuse of process. That is the way it's placed in the grounds of appeal, and that is what we deal with. And subject to how your lordships and my lady would wish us to proceed, what I shall do, as expeditiously as I properly can do in the circumstances, is to deal briefly with the type of media material that underlies the application. And I shall do that briefly because I know the court has been provided with a detailed schedule of material as the court was in the Crown Court. I shall endeavour to explain why we respectfully submit that this does fall under either or both of the limbs of abuse of process. And we shall address specific issues that have arisen in the circumstances of this application, considering the ruling of the learned judge and the respondent's notice. And to assist my lord, in addition to going through or outlining what is in the grounds of appeal, those issues that arise that the court may wish to hear our response upon are, first of all, how we say that unfairness arises irrespective of the accuracy of media coverage. I'll develop it when I get to that, if I may. Secondly, why the approach to meeting prejudice as set out in the authority of Montgomery and H.M. Advocate, 2003, one appeal cases 641, relied upon by the respondent at trial and in its application, is no remedy to prejudice in this case, why we say it is not, respectfully. Thirdly, why the submissions we advance on behalf of the applicant are not a mandate for those convicted of the most grave and serious crimes to be immune from future prosecution, because that's one matter raised by the respondent. And then finally, why comments, or the comments we identified by the police and the prosecution, can properly come for consideration under the second limb of abuse, whether or not one categorises them as bad faith or misconduct. And in embarking upon the application, my lord, we recognise that anyone with experience of the criminal jurisdiction and abuse of process will know, if I may put this respectfully, what a shield wall of appellate authority I face in making the submissions that I do. But we do submit it as an exceptional case with exceptional media interest, and therefore exceptionally, unfairness is capable of arising, notwithstanding the safeguards that are often employed to deal with matters that we raise. Before turning to the media material, which I will deal with briefly, succinctly, may I make these observations at the outset, my Lord? First of all, as the court will have in mind, we're dealing with the impact of media coverage and public comment arising out of the original convictions at the first trial upon the second. We take those convictions in these submissions as a given, and we will make reference to the factual accuracy of the coverage. But it is important, as the court knows, for me to identify that the applicant maintains and has maintained she's not guilty of the offences. And so I simply make that clear so that in no way is my treatment of the convictions in taking them as a given in the context of this application a concession on her behalf. It's right that I say that. The court may well understand that in any event, but I say that. Secondly, my Lord, the application focuses on matters independent of the evidence in the trial itself. That's apparent from your Lordship's observations at the outset. Now, the evidence and the course of the trial are set out in detail in the advice and grounds, but the application relates to the question of prejudice arising from media coverage. It's a narrow application, and therefore, unless called upon to do so, we do not refer to the detail of the case itself in this hearing. But I emphasize that isn't to disregard the enormity of what the trial was about, or its impact and the experience upon the family of baby Kay. And no disrespect is intended by us by the fact that she and those events feature so little in this application. It's because it is a narrow application on one point of law. And the final initial observation before I move to the application is this, that it may be easy for some to forget that we're going back to the media environment of August and September 2023, and that's a very different environment from the one that exists now. And at that point, it was, we respectfully observe, saturated with unadulterated vitriol towards Miss Letby. And that ran from those in high political office to the police, representatives of the prosecution, and across every media outlet. So the question of whether the trial that followed could be fair necessarily is considered in that context. Very different from the one applying now, perhaps. The basic statement, and I don't propose to rehearse the law, unless there are points the court wishes to raise with us. But I just say this, the basic statement of the power to stay proceedings on the basis of abuse of process we set out in paragraph 64 of the perfected grounds. It comes from the authority of the Crown and Maxwell, 2011, 1 Weekly Law Reports 1837. It's well established. The power to stay proceedings on the basis of abuse of process may arise in two categories. First, where it will be impossible to give the accused a fair trial, and second, where it offends the court's sense of justice and propriety to be asked to try the accused in the particular circumstances of the case. And our submission, my Lord, is that the media coverage following Trial 1, particularly in the immediate aftermath, and the attendant comment contain elements that fall across one or indeed both of those limbs. When the matter was dealt with before Mr. Justice Goss, and in setting it out in the perfected grounds, we placed the media material in three categories set out in paragraph 61. The first was that it led to overwhelming and irremediable prejudice to the defendant on the basis of the extent and detail of coverage and comment across all forms of media in the aftermath of the verdicts. And that included comment by witnesses, witnesses who might give evidence at the retrial at a time when a retrial was under consideration. That was the first area of complaint. The second was that there had been highly prejudicial and emotive public comment by police officers charged with the investigation and by the Crown Prosecution Service, or at least one representative, at a time when retrial was under consideration. And the third area of comment was that public statements by police officers charged with the investigation as to further potential crimes by the defendant and investigation into these had been made at a time when retrial was under consideration, and there was media coverage of that. Those characterizations are based upon the material set out in the schedule and also the matters related to the medical witness, Dr. Jairam, all within the composite bundle. It's detailed and relatively lengthy, and I don't propose to start to recite all of that now. All I do, so that when I make the submissions I do, it is apparent why we make them, and also keeping in mind the public nature of the hearing, is to provide a very brief summary of the type of material, and it will be brief. Some of the material we submit, and we said there's 6 types really, but some of the material is straight hostile comment. And I'll give the item numbers. Items 8 and 16 and 41 are examples of that. On mainstream television, for example, Panorama, viewed by millions, or the programme Loose Women, popular media programme, in which the defendant was referred to variously as evil or depraved, and the Loose Women treatment at item 41 was Lucy Letby born evil, and discussion like that. That's the general comment. Secondly, comment by the Crown Prosecution Service, or at least one representative, set out in items 1, which is from Sky News, and 9, which was Channel 4 News, coming from the prosecution, describing the defendant, who he recognised had just been convicted of these crimes, as devious, cold-blooded, calculated, manipulative, and cunning. Someone who was perverting her skills and weaponizing her tools. And when we come to it, the complaint is that that is said in the context of that representative and the prosecution considering a retrial whilst that was happening. We also observe, and I'll develop this point, that is a far cry from factual matters, that type of comment. Third, comment by investigating officers. The court will find this variously throughout the schedule, but at items 2 and 6, and 9 and 27, by way of example, from senior officers describing, still engaged in the investigation, still engaged in the decision of whether or not there would be a retrial, describing the applicant as manipulative, getting away with murder, horrible, horrific, evil, cool, devoid of emotion. Fourth, principally by the police, reference to ongoing investigations. Appearing on Sky News at item 1, ITV News at item 5, Daily Mail at item 6, and the Independent website at item 14. Outlining by senior officers the investigation continuing into up to 4,000 cases, not suggesting that all would be offences, but there would be a thorough review, and that figure repeated itself. And we observe in passing nothing to do...
I'm sorry to interrupt.
My lord.
Maybe my misunderstanding. The 4,000 cases is 4,000 children,
yes,
very young babies, who had been admitted to units at which Ms. Letby had worked at the relevant times. Now, that was then translated by sub-editors or whatever into what one might call hyperbole, but that's what the police were saying.
My lord, yes, they were. Is it Paul Hughes in particular, who'd been a senior officer in the investigation, dealt with this. And the figure of 4,000 was given on the basis that was the extent of the review because of other babies that the defendant had come into contact with. And in fact, he did say, and this is at item 6, that this doesn't mean we're investigating all 4,000. It just means we are committed to a thorough review of every admission from a medical perspective to ensure that nothing is missed throughout the entirety of her employment as a nurse. And so it's quite right that, and we don't suggest that we're saying there were 4,000 other offences to be proceeded with, but what was put into the public domain at a time when the prosecution were actively considering retrial was the possibility of further offences and an investigation into the same, which would be, we respectfully submit, quite extraordinary from a standing start in criminal litigation if a trial was about to take place and an utterance like that was made.
I'm sorry I interrupted.
No, not at all. The fifth area, there were 6, so we're nearly there with the summary, but the fifth area was comment by public figures. No control over that, of course, but it is a feature of this case that it attracted comment from the Prime Minister and others in public office. We deal with that at item 23 of the schedule. It has to be said mostly that was due to the applicant not coming into court for sentence, but nevertheless it was against a background of intense hostility towards her. And then finally, comment by various witnesses, but perhaps most notably Dr. Ravi Jayaram, who was a lead witness in the trial that was to take place. He generated a good deal of material. We set that out. It's in a particular part of the bundle at items, in the composite bundle, items tabs 13, 14, and 15. And I don't go there now because the court is well able to do so. But tab 15 in particular sets out the volume of material generated by that witness that was almost entirely self-serving, given the trial that was about to take place. In itself, that is prejudicial, but we do complain and did complain of the fact there appears to have been absolutely no effort to restrain that witness from engaging in an almost perpetual narrative that had the effect of bolstering his position and the account that he would go on to give at trial. I'm grateful for the opportunity to summarise that material. There's a lot of it, and I've endeavoured to do so, but I shall move to the submissions that we make then as to the 2 grounds.
Yes.
Thank you, my Lord. I'll deal first of all with why we respectfully submit that the first category of abuse of process is engaged in this case. That being using the Maxwell characterisation that the applicant could not receive a fair trial. And we ask the court to consider this in the light of the totality of the media material identified, which are examples of what took place. And we submit it was exceptional, it was deeply prejudicial, and will be bound to have had a lasting impact on members of the public, including those who became jurors in due course. Our principal response to this by the respondent in the Crown Court and in the response to this court was as to the accuracy of the material underlying the comment. And I don't seek to present my learned friend's arguments for them, but the argument really was, well, this is principally comment upon material that is accurate, and there can be no complaint about accurate reporting. I apologise if I don't do full justice to the argument.
Well, he can make his own argument in due course.
He will do, and identify it. Our submission was and remains that the accuracy of the material is not the issue, and the accuracy of the underlying material, the convictions and the facts, is not an issue. And nor do we, or have we made criticism of the reporting of that insofar as it simply reported what took place. There is no criticism of the reporting. But accompanied with that is comment and presentation that reflects shock and outrage and condemnation, which may be unsurprising. But that's how it was. The prejudice occasioned by that is quite distinct from questions of accuracy, and accuracy is no answer to this complaint. And the reporting of the convictions is not the issue. And indeed, the defence at trial recognised that it is inevitable, and was inevitable, that those convictions would form part of the evidence that the jury would hear in any event. How could they not? We recognise that. And therefore, they could hardly be missed by anybody, and certainly wouldn't in the course of the trial. But it is the accompanying hostile comment that we submit, my Lord, is the huge problem from, as we've shown, public figures from the very top and throughout all levels. And the fact, this is a submission that we rely upon, the fact that the prejudice attaches inevitably to the convictions makes it far more difficult to control or alleviate it. Because as soon as those convictions are referred to, we submit, it's inevitable that all the comment and everything that's accompanied them in the public domain then comes to the front of any recollection of them. I'll respectfully give an example of why we say prejudice, if there is prejudice, is not justified or ameliorated by accuracy. And I do it in this way, and I appreciate this is hypothetical, that if the order of the trials had been reversed, if trial 1, one count of attempted murder, were to be followed by a trial of 22 other offences, I respectfully submit that an order under Section 4.2 of the Contempt of Court Act would be unremarkable. Not because of any concerns about the accuracy of the reporting of what was going to be in that one trial, but because it's recognised the potential impact of that upon the fairness of a following trial could interfere with the administration of justice. And by extension, I respectfully submit, my Lord, that if there was a 22-count indictment for trial to be followed by 1 count, the argument would apply, in fact, with just as much force, if not more so, because of the massive amount of prejudice upon the 1 count that would follow. Now, of course, we recognise knowledge of what was going to happen was not available to everybody, but it's a significant feature of the application we make that these things were said at a time when retrial was under consideration. And for that reason, and with that example, we submit that it can be no answer to prejudice to say, well, the reporting is accurate or based upon accurate material or fact or convictions. For the same reason, we respectfully submit that the heinous nature of the crimes themselves is no answer to the application. We note the content of the learned judge's sentencing comments at paragraph 7 of the respondent's notice, and they featured in the respondent's reply to our submission at trial. And we recognise the recital of those sentencing comments from the first trial is a dramatic reminder of what those crimes were and how the learned judge viewed them. But we respectfully submit that cannot be relied upon by the respondent to justify unfairness, because however the learned judge expressed that, and one can understand how and why he did in the context of the convictions, repeated and unrestrained saturation coverage goes well beyond those comments. And it does not cast light on how to deal with this. And, my Lord, in seeking to persuade the court to consider this application, the respondent in seeking to persuade the court to do this in terms of the convictions and the fact that what followed is simply a function of the convictions rather than comment, and that's dealt with in paragraphs 35 and 47 of the respondent's argument. In seeking to do that, to draw that distinction, we respectfully submit that the respondent advances, in effect, a false dichotomy between those two things, between conviction on the one hand and comment on the other. And I make it plain, we mean no discourtesy by the use of the word false. I use that in a philosophical rather than an ethical context. It's not a proper distinction between the two, because there can be no distinction between conviction and comment in the way it was dealt with in the media in this case, as if one can be hived off from the other. The comment is inextricably bound to the convictions, and that is the point, my Lord, and that is why it's so difficult to diminish the prejudice, because necessarily the convictions coming into the trial play a part in importing all the comment back into the trial that are inextricably bound with them in the public domain. Our submission, therefore, considering that, is that if the prejudice created by media coverage is so great there cannot be a fair trial, then the abuse is established, and we respectfully submit that is the position, given the intense hostility and the saturation. Now, we recognise that the remedy invariably, when the court is presented with a situation like this, is the trial process itself. That is the principal approach taken by the prosecution. That plays an important part in the learned judge's ruling, and we recognise that, and we respect that argument. We understand why that is the case. And reliance is placed upon the authority of Montgomery, which goes into some detail as to how that applies. Again, I shall deal with this as succinctly as I can, but Montgomery features quite heavily and may feature in the response, and therefore perhaps I could deal with this, my lord. Montgomery is included in the composite bundle from page 65 of that bundle, which is CACD 1B4, item 12. It's said that the facts of Montgomery, or Montgomery itself, is similar to the instant matter. And saying that, the respondent therefore advances that the solution to prejudice is the same. And we respectfully submit it really is very different, both in terms of fact and in terms of where the jurisprudence takes us. In Montgomery, there were 3 potential defendants for an allegation of murder. Only one was proceeded against initially. He was tried for murder but was convicted of assault and acquitted of murder. And there was then much public comment as to whether or not the other 2 defendants should be tried for murder, that first trial having taken place. Much of that was directed at a disagreement that developed between the trial judge and the Lord Advocate. But in any event, defendants 2 and 3 came to be put on trial, and the issue arose of what is the status or the remedy to the publicity affecting that trial after we followed the first trial. So to that extent, we recognise why the respondent goes to Montgomery. The first part of the analysis deals with consideration of how to approach devolution issues. We don't propose to go there. No. The second part, part B as it's put, from page 83 in the composite bundle, deals with the question of pre-trial publicity. And in considering the position in this case, my lord, I shall deal with the key points arising from that, although we'll endeavour to assist if anything else arises. The references I use are pagination in the composite bundle. Lord Hope, who dealt with this, the key ruling. On page 85 of the composite bundle, just above the italicized words, the test. This is said that, as this passage indicates, it's the effect of the publication, in this case the series of publications, on the mind of the notional juror at the time of the trial that has to be considered. And the risk assessment exercise requires account to be taken of the factors, including the measures available to the trial judge that may be expected to reduce the residual impact. At page 87, it's about halfway down page 87, unfortunately the paragraphs aren't numbered, but page 87 of the composite bundle, it's identified, having reviewed the way in which this is dealt with and concerns about publicity, that the passages indicate, it's halfway down the page, that the decisive question is whether the doubts which the defendants have raised about the impartiality of the tribunal, or in this case we would say any unfairness arising from the minds of the jury, can be held to be objectively justified, and that in a case which is to be tried under the solemn procedure, the tribunal includes not only the jury but also the trial judge. Thus the question is not confined to residual effect of the publicity on the minds of each of the jurors. Account must also be taken of the part which the judge will play in order to ensure, so far as possible, the defendants will receive a fair trial. I make it plain, we're not endeavouring to perceive what lies within the mind of the trial judge and make no complaint of that. But it's the direction of travel, which is that the trial process holds the answer to this, that we identify from this. And that is quite evident when one comes to page 90, where Lord Hope encapsulates, we respectfully submit, where he gets to in the analysis. It's at the top of page 90, a couple of lines in, where he says, the principal safeguards of the objective impartiality of the tribunal lie in the trial process itself and the conduct of the trial by the trial judge. On the one hand, there is the discipline to which the jury will be subjected of listening to and thinking about the evidence. the actions of seeing and hearing the witnesses may be expected to have a far greater impact on their minds than such residual recollections as may exist about reports about the case in the media. This impact can be expected to be reinforced, on the other hand, by such warnings and directions as the trial judge may think it appropriate to give them as the trial proceeds, in particular, when he delivers his charge before they retire to consider their verdict. And the approach, my Lord, is that it's the combination of the trial process in which the jury are disabused of the prejudices which have been created by what they heard pre-trial, combined with judicial direction, that is the route to avoid unfairness and to make sure the trial is fair. But of course, the remedy in Montgomery is applicable in that case because a trial was due to take place. Notwithstanding there had been a trial of D1, there was to be a trial of D2 and D3, and no trial had taken place concerning them. And so the issues could be determined freshly. Here, that does not apply. The material to which the prejudice attaches exclusively comes out of Trial 1 and has been determined at the conclusion of a trial process. There was no way in which the jury in Trial 2 were going to have the publicity and the comment and the hostility ameliorated by seeing what the actual evidence was that lay behind that. That's a crucial part of Montgomery, and indeed we respectfully submit that part of the twin dynamic, direction plus the trial process, is a crucial part of the way in which the courts seek to meet the question of prejudice where there has been a blaze of adverse publicity. And this was a long blaze. It lasted about 5 or 6 weeks. We'll come to the question of fade factor shortly. But we submit that the unfair prejudice could not be remedied by consideration of evidence and the trial process because it came out of that. And we observe in passing cases such as Abu Hamza 2007 1 Criminal Appeal Reports 27. Also, when it looks at other authorities and other cases of note in this area, comes to the conclusion that it is the trial process which is the necessary corrective, and that does not apply here, we respectfully submit. So, the trial process cannot assist. Accuracy of the content of media reports, we respectfully submit, is no answer to this. There were measures taken by the learned judge, there's the pre-trial questionnaire, to which additional questions were put to see if the jury could identify anything which would interfere with their ability to deal with the trial properly. I, of course, cannot be the final arbiter on the cognitive processes of the jury. All we can say on behalf of the applicant is that when there is this volume and extent of vitriolic publicity, the extent to which bias may exist may go well beyond the ability of the individual to identify it. And that is why it's necessary for the court sometimes to step in and shape the decision as to where fairness lies. We say questionnaire could not meet this. Nor we respectfully submit for the same reasons could judicial direction on its own. The evidence, I apologise, the publicity was overwhelming and almost nobody could have been immune to it, and it's difficult to see how any direction could meet that. This court will form its own conclusion, my lord. I know that it's an exceptional case with an exceptional volume and intensity of coverage. We do not respectfully accept that the fade factor can in any way deal with this case. It ignores the reality of the situation. The trial had lasted for 10 months. It was widely anticipated. It was reported extensively and in minute detail. And it was then followed by weeks of this coverage across every area. The level of reporting ceased when a retrial was fixed, but the prejudicial material remained in the public domain for any and all to see, and that retrial was widely anticipated. And we say respectfully, it is unrealistic to regard anything about this case as fading at any point. Those headlines with the evil and the rest of it that goes with it creates a lasting impression. We understand the matter identified by the prosecution, by the respondent, I apologise, at paragraph 4, which is the potential difficulty that if the worst cases create the worst publicity, then how is one ever to deal with the most notorious cases when they come to trial? And that is a problem with which the courts repeatedly have to grapple. Context, as the respondent regularly says, is important. Our submission is not a submission seeking immunity for further prosecutions. It doesn't establish that. But the starting point has to be, however difficult it may be, and this is drawing to a conclusion with ground one of our application, that the principle of fair trial has to and does apply to everybody, whoever they are, and however heinous the background to the case. It's the same whatever the background. Save that we observe it may be very much more difficult to achieve in the context of heinous previous convictions. Now, if the respondent is correct, the consequence would be that anyone can say pretty much whatever they want, and if the crimes are bad enough, too bad. I don't say that disrespectfully. I reduce it to a very simple formula. And if I'm wrong about that, I will be corrected. But we submit that's the problem with the way that is put. We understand the attraction of that in uninformed quarters. This is such a case where the publicity was appalling because it came out of convictions that were shocking. But the fundamental question on ground one is fairness, whoever the defendant is and whatever they have done previously. And however we get to the situation that we did at the beginning of trial 2, we respectfully submit that this could not be a fair trial in terms of confidence in a jury free to act objectively and impartially and unencumbered by prejudice arising from saturation coverage of a deeply hostile character from every angle. And we submit respectfully that the requirements of ground one are satisfied in that context. That's the application we make, my Lord, with regard to the first limb of abuse. I'll turn to the second. Just so that the submissions can be in context with the law as the court well knows it to be, just as a starting point, just recite what the test is, if I may, and then I can develop the arguments we present. Set out at paragraph 64 through to 66 of the perfected grounds. But the second category where abuse may arise is where there is material or events that offend the court's sense of justice and propriety, that it should be asked to try the accused in the particular circumstances of the case. Again, I rely upon the formula advanced by Lord Dyson in the case of Crown and Maxwell. And in that same case, at paragraph 13, which is in the composite bundle at page 155, Lord Dyson, drawing upon other authorities, described further what that second category of abuse would be. He gave examples and said that a stay would be granted where the court concludes, or identified that it would be granted where the court concludes that in all the circumstances, a trial will A, offend the court's sense of justice and propriety, and that comes out of Crown and Horse Free Road Magistrates Court, ex parte Bennett, or B, where in the circumstances it would undermine public confidence in the criminal justice system and bring it into disrepute for the trial to follow. And we recognise at the outset this is not geared to unfairness to the defendant in the sense that the first limb is. This is a different species of abuse altogether, and it is the court protecting its own process against any type of abuse or unfairness. The material we rely upon in advancing this ground focuses upon that which comes from, to a limited extent, the Crown Prosecution Service, and it is one person in particular, and we've identified where that is in the media. We seek not to overstate the position. It is what it is, and it's limited to that from the Crown Prosecution Service, but also quite a lot of comment by officers, and importantly, officers associated with the case and the ongoing investigation, at a time when they knew retrial was under consideration.
And this is the material you've already referred to?
Yes. I'm not going to return to it.
No, just so we're clear.
Yes, I've dealt with it. I hasten to add, I've dealt with it in relatively short form.
Yes, well, we've got the full schedule. Yeah.
But it is, we respectfully submit, unprecedented for comment like that to be made in advance of a trial. So personal, so critical of the defendant, so subjective, and identifying further lines of inquiry on quite a large scale. And it undoubtedly does, my Lord. We recognise the figure of 4,000 is not the number of cases, but there is no doubt when one goes through that material, they are identifying there may be more out there, and this is what we're looking at. And that's powerful stuff, and put into the public domain. The test under the second limb has been refined over time, and two authorities in particular occupied the court's consideration at trial. And those were the authorities of the Crown and Norman 2016 EWCA Criminal 1564, and that starts in the composite bundle at page 192, and the case of Ing, and I hope I pronounced that correctly, and I apologise if I don't. Yeah. And that's at page 178 of the composite bundle, and the citation is 2024 England Wales Court of Appeal Crim 493. And in both of those cases, in effect, a two-stage test was identified when questions of unfairness arise under the second limb, as described in Maxwell, a two-stage approach. First, there is the requirement to identify misconduct and what the misconduct is. I summarise, but for the assistance of the court, my Lord, in Norman, this is dealt with in paragraph 23, which is in the composite bundle at page 198. And in Ing, it's at paragraphs 23 to 25, composite bundle page 183. And we respectfully recognise that comes from the Lady Chief Justice this year, and so it could be said to be one of the most up-to-date guidelines on the way this should be approached. So I approach with appropriate circumspection in what I say. But a two-stage approach is defined. First, the requirement to identify misconduct, and then, if or where it's identified, there must be an evaluation of the facts and circumstances, weighing into the balance the public interest in ensuring those charged with crimes should be tried against competing public interest in maintaining confidence in the criminal justice system. Those words from the Lady Chief Justice in Ing at paragraph 24. Now, our response to this is twofold. And in the submissions before the court, some mileage was made of the fact that in our initial submissions to the trial judge, we made it plain we weren't alleging bad faith specifically, nor were we putting it in terms of misconduct. We identified what the material was, as we have done to this court, and that is what we complained about. And on the second day, as we went into the following morning, I was provided with a copy of Ing by the trial judge, which set out the position very plainly from that authority. And we then took the position, well, however it's described, we say this is wrong. If it has to be called misconduct, we say it's misconduct, but it's wrong what took place. So let me deal with that first of all, because the respondent identifies it naturally in paragraphs 45 and 49. And we say this, the first of the 2 points in answer to Norman and Ing. If it was a mistake for us, or let me take that, for me to use temperate language in my submissions to the court, I recognise that, and so be it. We presented the position temperately. At all times we made complaint of that, but if it wasn't presented in lurid enough terms, that's where that takes us. But it is the nature of the conduct that matters, we respectfully submit, not the label. It's the nature. If the police and the prosecution launch into blistering attacks on a defendant who may yet face trial for matters they continue to deal with, that is wrong. Whatever word is used for it, it is wrong. If they describe further inquiries they intend to make into thousands of cases, and they do that when they know that retrial is under consideration because they asked for that to be considered, that is wrong. Whatever label is applied to it. and if they don't even attempt to keep in check the self-serving public commentary of the prosecution lead witness in the case, that is wrong. So, we respectfully submit, when coming to consider the second limb of abuse, that it offends the court's sense of justice and propriety to try the accused in the particular circumstances of the case, we respectfully submit that conduct such as that we identify should offend the court's sense of justice and propriety, whatever label we attach to it. The second reason that we can identify this material for the court is that Norman and Ing have elaborated upon the law as it was stated in Maxwell, drawing upon ex parte Bennett and Latif in setting out what the second limb of abuse was. I've dealt with the formulation in Norman and Ing, in particular with the view to misconduct. Now, in fact, if one goes to Maxwell, where this begins, that doesn't set out requirements specifically for bad faith or misconduct, or any particular formulation of what constitutes an offence to the court's sense of justice and propriety. And my lord, I go to page 155 of the composite bundle, which is from Maxwell, and paragraph 14, in which a particular passage from Latif, coming from Lord Steyne, was set out, and upon which the court in Maxwell relied. And if the court would look into that passage, we see, pretty much in the middle of the text, that it said that an infinite variety of cases could arise. This is dealing with the second limb. General guidance as to how the discretion should be exercised in particular circumstances will not be useful. So recognizing the weight of the court in Norman and in Ing, I proceed with caution, but it is, we respectfully submit, significant that the root of the second limb of abuse is much more broad than simply a formulation of misconduct, although that may come to it, and it should not, we respectfully submit, be limited to that. And indeed, the case of Warren and Attorney General for Jersey, one appeal cases 2012 at page 22, paragraphs 23 and 25 of that authority, which are at page 216 of the composite bundle. Paragraph 25 in particular, says the board considers that it is a useful summary of some of the factors that are frequently taken into account by the courts when carrying out the balancing exercise referred to by Lord Steyne in R and Latif. But it is also necessary to keep in mind his salutary words that an infinite variety of cases can arise, and how the discretion should be exercised will depend on the particular circumstances of the case. And so, whilst the narrowing of focus upon what is described as misconduct in Norman and then in Ing is powerful assistance in interpreting how to apply the second limb of abuse, we respectfully submit that to bind that to terms like bad faith or misconduct as if they are mandatory requirements cannot follow from where the roots of the second limb of abuse lie, and that would be an unjustified constraint in considering what is capable of amounting to that. And the proper way of approaching it is to regard these as powerful examples but not prescriptive requirements. And approached in that way, the conduct of the prosecution and the police in terms of their public statements is, we submit, capable of amounting to an abuse under the second limb. And to some extent, but not entirely, the 2 points we make in answer to this are aspects of one another, but there are subtle differences. First of all, that it doesn't matter what the label is, that was our first point. And secondly, that in any event, the categories of abuse here are not closed or limited by any particular formulation. And we're grateful to deal with that in some detail because it's a significant part of the response. It's important to identify why we rely upon that material. And so, my lord, that being so, and if we are right that it can at least come for consideration under the second limb, if we get to that point, then the real issue is whether, on balance, the public interest in proceeding with this trial outweighed the extent to which justice and propriety were offended. And as to that, we recognise, being temperate and realistic in our submissions, that the balance is a fine one. Because when counsel recognises the balance is a fine one, that isn't necessarily a precursor for saying that the respondent must therefore be correct, because that doesn't follow. The balance can be fine and come down in favour of the applicant. And we say that is the appropriate resolution of that in this case, where the police have embarked upon a media campaign, which undoubtedly this was. We haven't gone to everything in the schedule, but there are websites in which they set out what they did and how they did it, and publicising all the work they'd done. It was a campaign, and embarked upon it in such emotively charged circumstances against a background of multiple convictions for the most grave offences, and importantly, where they knew that a retrial was under consideration and was a possibility, then that is, we say, unfair and can properly offend the court's sense of justice and propriety. It really is not what should happen at all. And in the circumstances of this case, and bearing in mind all that had already happened, the public interest could be met by finding there to be an abuse, because in our submission and in conclusion with regard to this, it is inimical to the interests of justice that those responsible for investigating the matter and bringing it to trial should generate material that creates powerful prejudice against the defendant, while simultaneously bolstering their own status. We submit that is what happened, and it can properly and should offend the court's sense of justice and propriety. For that reason, recognising the balance is a fine one, nevertheless we submit that the requirements of the second limb of abuse are met. And for that reason we say that this material, or elements of it, meets that. My Lord, my Lady, I'm grateful for the opportunity to set that out to the court. If there are further matters to deal with now, I shall endeavour to do so. Otherwise, I can respond if necessary when further submissions have been taken.
I shall see if my Lord has anything he wants to ask. My Lady? No? I think you answered this already, at least implicitly. The evidence of the previous convictions, i.e. the trial convictions, first trial convictions, went before the jury, and was that by agreement?
It was, my Lord, yes.
And you've explained why?
Yes.
Yes. All right. Thank you very much indeed. Yes, Mr. Johnson.
May it please you, my Lord, my Lady. You have received very long written submissions from both sides. If they were overlong from our point of view, I apologise. But the advantage, of course, if there is one, is that it probably reduces the amount of time that I need now to develop the arguments.
Yes.
The publicity has been characterised this morning as unadulterated vitriol. We don't for a minute accept that as anything like a reasonable or accurate characterisation. What was said by the police in the aftermath of the convictions in the first trial was reasonable. It accurately and moderately described the horrendous offences of which this applicant had been convicted. And just taking up on a point that my Lord has just clarified with my learned friend, those offences were admissible evidence in the retrial. And that really, in a single paragraph, summarises the conundrum or the difficulty we submit for this application. In making the submission to the learned trial judge and in its renewal today, the applicant relies on 62 elements of, or particulars of, publicity. And it merits, we would submit, just looking at when those articles were published or those television programs were broadcast. On Friday the 18th of August, which was the day of the conviction, there were 16 items from the schedule, number 1 and numbers 3 to 17. Of those items, numbers 1, 3 through 1, 3, 4, 5, 7, 8, 9, 10, 16 and 17 were on the television. There was a good deal of overlap between that material. And the Panorama programme was item number 16. One of the items focused on the hospital management. So how, for example, that could possibly fall within the characterization given this morning, we respectfully query. The following day, the 19th of August, there were 10 items. They're items 18 to 27. Items 22 and 27 were news items which focused on the hospital management. This is not unadulterated vitriol aimed at the defendant. The other 8 items were all written news, most of which focused on the hospital management. The exceptions to that were item 18, which was where it was reported that the police were continuing their investigations. I pause there for a second to respectfully observe, in the context of these convictions, a statement of anything different would have been astonishing. Item 19, which recycled material from the previous day. Item 21, which focused on Lucy Letby's grievance against the hospital for being suspended from the neonatal unit and her treatment by the management of the hospital as a victim. And item 25, which described how Lucy Letby gave evidence in her defence. That certainly wasn't vitriolic. And item 26, which reported the interviewing officer's assessment of the applicant's lack of emotion when she was interviewed and gave evidence in her own defence. So far, that's 26 of the 62 items within 48 hours of the conviction, months and months before the retrial. Sunday, the 20th of August, 4 items. One can already detect the familiar pattern of the news cycle. We've gone from 16 on the day to 10 the following day to 4 on the Sunday. Nothing on the television. A 15-second TikTok Sky News clip of Detective Superintendent Hughes recounting the emotional impact of the investigation. That's not unadulterated vitriol aimed at the defendant. The 3 other items concern the continuing inquiries and the fact that the different babies' cases that had featured in the trial had been investigated by different teams of detectives in order to avoid groupthink. That's got nothing to do with the defendant. Monday, the 21st of August. the day that sentence was imposed. Predictably, the news cycle got a second wind. 10 items. Items 32, 33, 35, 36 to 38, 48, 54, 55, and 58. 7 of those were television programs or transmissions. They concerned principally the sentence hearing, Lucy Letby's non-attendance, the desired format of a public inquiry, the culpability of the management at the hospital, and the suggestion that the managers should be regulated in the same way as the nursing staff and the medical clinicians. Items 36 and 38 are almost identical. None of that material was directed at Lucy Letby, even less does any of that material justify the description of being vitriolic. The 3 newspaper articles were items 33, 48, and 54. They addressed the contrast between what had been proved by the convictions and the continuing support that Lucy Letby enjoyed from her friends. That was not vitriolic. There was an arcane medical post on LinkedIn. And there was the Herald Wales report of a selection of the television material that had already been transmitted. Tuesday, the 22nd of August, the news cycle was losing momentum. 4 items, items 2, 39, 40, and 44. The two television items were 39 and 40. Item 39 was an explanation of Dr. Sandy Bowen's role as a witness with a call for a full public inquiry. Not vitriolic, not aimed at the applicant. Item 40 was a chat show which concentrated on the issue of whether there should be CCTV in neonatal units. And at the end, something my learned friend has just referred to, a very short consideration of whether or not people are, quote, born evil, close quote. The other 2 items were a podcast in which Superintendent Hughes explained the police approach to the investigation. Again, not focused on the applicant. And finally, a newspaper article that focused on the management's shortcomings. Again, only tangentially referring to the applicant. Wednesday, the 23rd of August. So we're now 5 days on from the verdict. 5 items, 41, 43, 45, 47, and 52. 2 of those were television or YouTube broadcasts, items 41 and 43. 41 was a discussion with a couple whose child had been in the neonatal unit, but was not part of the case. And 43 was a series of stills from inside Lucy Letby's house with a commentary. That attracted comments from viewers, which have been reproduced in the applicant's bundle, which principally are directed at the shortcomings of the hospital management. The 3 Twitter/X or newspaper items all focused on the shortcomings of the hospital management. So again, to suggest that this body of material was unadulterated and vitriolic and directed at the applicant is to misrepresent the reality of what we're dealing with. Thursday, the 24th of August, 2 items, both in newspapers, items 42 and 46. 42 included quotations from the inquiry team concerning what was on their minds during the investigation. And item 46 was a speculative article concerning the consideration of a potential link between asterisks in Lucy Letby's diary and offences she had committed. Neither of those justify the epithet that's been given this morning. 7 days on from verdict, the 25th of August, 2 newspaper articles, numbers 49 and 50, both from the Mirror. The first concerning parents whose child had been in the unit and their contact with Lucy Letby, and the second was entitled, quote, "Inside Lucy's Beige Home." Well, I pause rhetorically to ask, what is the greater insult, being referred to as a serial killer of babies, something which had been proved, or being called beige? Beige certainly doesn't qualify as vitriolic. Saturday, the 26th of August, a single article published by the BBC, item 63, reporting that the Times had reported that ITN would be making a documentary. How on earth could that possibly be worthy of the epithet vitriolic? Monday, the 28th of August, 1 article in the Manchester Evening News, item 51, focusing on Dr. Bowen. The news cycle had almost lost interest. Thursday, the 31st of August, a single article, number 53, in the Times, calling for more medically qualified members of hospital boards. We then move on almost 3 weeks, 2.5 weeks, to the 17th of September. 1 article in the Daily Telegraph, it's item 34, recycling material from the Daily Mail podcast. So the Telegraph copying the homework of the Daily Mail. The 23rd of September, item 56, ITV news footage of an interview with a nurse, Abby Lever, who worked on the neonatal unit. It is not anti-Lucy Letby. The 4th of October, Talk TV interview, item 59, with Dr. Evans, which focuses on the culpability of the hospital management. Exactly the same subject as item 36 on the 21st of August. Sometime late in 2023, and it's not easy to be sure of the precise date, item 57, an article from LinkedIn Express Nursing, focusing on the disparity between the tight regulation of medics and nurses and the non-regulation of hospital managers. We then come to the 3 items in 2024. The first is item 60, which is a Twitter or X post from the BMJ leader, aimed at hospital managers. The 22nd of March, item 61. Dr. Jerem featured in a Sky News programme saying to the effect that clinical staff were being intimidated by hospital managers. And then finally, the 14th of May 2024, item 62, the much discussed New Yorker article, which is very, very pro-Lucy Letby, suggesting that she had been wrongly convicted. This was circulating on X or Twitter in the weeks before the retrial. It was given significant traction under the protection of parliamentary privilege by Sir David Davis. And if ever this court wants evidence that publicity had no effect on this jury, this is it. Because this was very pro-Letby, anti-prosecution material circulating with significant traction on the internet in the weeks and days before the trial, which was very much to the advantage of the applicant. And so, my lords and my lady, in that context, one remembers the old epithet that today's front page is tomorrow's fish and chip wrappers. And that's a more homely way of articulating the point or the concept with which this court is well familiar, which in legal circles is usually called the fade factor. Just taking a step back then, we have a situation in which there was a lot of publicity in the week or so after the convictions. That's not surprising. But whether or not it's surprising, was it prejudicial? And the answer we respectfully submit is absolutely it was not. It has been completely mischaracterized by the applicant in order to provide the factual foundation for the application that she now makes. Most of the material wasn't vitriolic, but insofar as it was disapproving, most of it actually was directed at the hospital management and the overwhelming support in the news media for the institution of a statutory public inquiry. That's the truth of it. So with that in mind, my Lord, can I just deal, I hope briefly, with the two species of abuse. Species one. Were the defence able to establish on the balance of probabilities that this defendant couldn't have a fair trial because the publicity would unfairly prejudice the jury? Well, what is the context? The context, as my Lord has already clarified, was that the woman in the dock was, as was known to the jury, if not when they came in, within a very short time of them being sworn, a multiple child murderer. And so it follows, we submit, that the trial court, had to take into account in assessing the sustainability of the application, that the jury was entitled, if they saw fit, to take into account that over a 12-month period, this appellant had murdered 7 children and had tried to murder 6 others, one of them on 2 separate occasions. And we submit that this application seeks either to distract from that fact or to relegate it to the periphery. And the consequence of that attempt at distraction, we submit, is to promote the notion that publicity in itself is objectionable. And we submit that that erroneously synonymizes publicity and prejudice. And a good example of that is the reliance on the New Yorker article. So just look at the fact that it was publicity rather than looking behind that to see what was actually being said. Another part of the context was that in the retrial, Lucy Letby could have called medical evidence in the retrial to establish that she was not guilty of the 14 offences of which she had been convicted. By the time the retrial started, 9 months had passed since the convictions, and yet she chose not to call that evidence. She could have called it, she chose not to. And so it follows that the learned judge, we submit, was ruling on an application to stay, knowing that this applicant wasn't even raising an evidential issue backed up with evidence concerning her convictions.
Well, I assume he knew that when she was to give evidence, she was to say, I did not commit any of these crimes.
Absolutely, my lord.
But your point is that's the only evidence she relied on to discharge the burden that was on her to demonstrate that she was not guilty.
Precisely, my lord. And in this context, given that the burden passes on the balance of probabilities to a defendant to disprove the convictions, any sensible dispute about the convictions necessarily, we would submit, would have had to have involved calling medical evidence. And so putting it another way, drawing all that material together, given the evidential matrix which was being presented to the court of trial, did the 62 publicity items either make a fair trial impossible, or, species 2, provide evidence to establish that the prosecution had acted in such a way as, to borrow the words of the Lady Chief Justice in paragraph 22 of Ng, it offends the court's sense of justice and propriety, or public confidence in the criminal justice system will be undermined for the defendant to be tried in the particular circumstances of the case. Such an abuse must amount to an affront to the public conscience. As I've already said, this application we submit confuses, conveniently for the applicant, but it confuses publicity or accurate reporting with prejudice. And it seems, given what's actually in most of these articles, it seems to us at least that what's really being suggested here is that the simple fact of publicity means that this applicant couldn't have a fair trial. We remarked at the time, in the context of the arguments before Mr. Justice Goss, and we continue to remark in the respondent's notice, that the material in support of the application hasn't been objectively analysed by the applicant in order to give credibility to the arguments that are being put forward. It's just summarised in that way it was this morning as being vitriolic. That's not, as I've already said, I'm repeating myself now, but that is not an accurate characterisation at all. Nowhere in the materials submitted in advance, or indeed in the submissions made this morning, is there any reasoned analysis of how that material exposes or exposed the applicant to a level of lasting opprobrium that extends beyond any revulsion inevitably linked to the facts of her convictions, which were, as has already been established, admissible evidence before the jury. And so, my Lord, if the applicant's argument is correct, in the absence of any such convincing analysis of how the publicity has genuinely had a prejudicial effect, in isolation from the fact of the convictions, it would follow that in any case in which there's been a lot of reporting and the offences being reported upon are extreme, that publicity must be prejudicial. And that simply is not correct. The law does not support that approach. And the consequence, we submit, of the applicant's confusion is that it promotes the idea that the more extreme and notorious the offending, the less likely it is that a trial or retrial can take place. And that is plainly contrary to the ends of justice. And that is pretty much set out at paragraphs 106 to 108 of the applicant's submissions. We submit that given the extreme nature of the offending, any comment that would be sufficient to support a species 1 submission of an abusive process would have to be very extreme, not to be susceptible to the fade factor. All the modern reported cases concerning publicity, misphrased that. All the modern reported cases concern public suggestions of the guilt of the offender, which comes into the sphere of potential jurors prior to the trial, the convoluted sentence. So, putting it another way, every time this court has been asked to rule on this type of application, it has been where, before an applicant has been tried, there has been what has been submitted to be prejudicial material in the public sphere. There isn't that in this case. Because all the publicity concerned offences of which the applicant had been convicted, and that was admissible evidence. And so in an effort to get beyond that fundamental problem, the applicant has submitted that comments made in the press by either the police or a representative of the CPS were, quote, highly prejudicial and emotive. But there's no analysis of what's actually said. And these comments we submit simply do not begin to justify that description.
Can I, Mr. Johnson, as you point out, what was said by Crown Prosecution Service employee and various police officers followed convictions.
Yes?
And in some cases, the sentence, which came a few days later. And it's the experience of those of us who practice in the criminal justice system that whereas 20, 30 years ago, somebody would be convicted of serious crime and a police officer might or might not say something about how helpful the witnesses had been, but you'd get very little comment about the nature of the defendant or
Yes.
the crimes. Whereas now it appears to be almost required for police officers to appear on the television and so forth.
Yes.
And so, Mr. Hughes, how would you describe the crimes of Lucy Letby? Horrible, horrific, and evil. That's the sort of language which is complained about. And that's something that police officers are perfectly entitled to say in the aftermath of a conviction. I think the complaint is that the police knew, because the issue had been left over at the conclusion of the trial, the police knew that there was a possibility that there might be a retrial of one or more of the counts on the indictment where the jury had failed to agree.
Yes.
And therefore, to engage in what, in all other circumstances, would be normal and unexceptional comment, that is what creates the prejudice. Now, how do you respond to that? That's, well, as I understand it, Mr.
Yes.
Myers' core point.
Absolutely. Well, that probably crosses both species potentially. So dealing with species one first. First of all, the comment is a measured comment to describe what has been proved and what was admissible in the retrial. And so the idea that it in some way prejudiced the applicant in the retrial, we would submit, doesn't bear much analysis. And secondly, whether or not I'm right about the first point, the idea that a juror in June 2024 would remember a couple of lines of adjectives or a description given by a police officer on television or on a podcast or in the printed media. The idea that a juror would remember that 9 months later simply doesn't bear any sensible analysis. And if I can give my Lord a more specific example of what I'm talking about, we all have read and considered this material in detail, in a quiet room, in anticipation of the fact that these issues are going to be raised in this court. And I can only speak for myself, but I venture to suggest that those of us who anticipate that we may need to refer to any of this material, either from the court's perspective in a judgment or from counsel's perspective in submissions, will have made a very careful list of specific words that appear in specific items. The idea that that material is carried around in our heads is unrealistic. The idea, and I'm now really borrowing from, I think it's the words of the Lord Justice General, Lord Emsley in Montgomery, who is quoted, I think, in Montgomery, making precisely this point, that it's all very well to complain about or to suggest that prejudice arises from publicity, but one needs to take a step back and be realistic about it. Most of this material washes over most people, even those who it doesn't wash over, don't remember specifics. And here we have a situation dealing with species 1, where it's for the applicant to establish her case. And the reality of the position, we respectfully submit, is that no juror would have remembered this material, even less in the context of what had been said by the learned trial judge, who expressed the position in arguably more forthright and detailed terms. Indeed, the very trial judge who retried this applicant. It wasn't suggested, and never could it have been suggested, that Mr. Justice Goss wasn't an appropriate trial judge for this case. The idea, therefore, that some really throwaway lines which pale into insignificance in the context of a comparison to the facts of the offences which were admissible evidence could create prejudice or injustice is, we submit, not a realistic submission. So, my Lord, that I'll come to species 2 in a second, if I may. I haven't forgotten that part of the issue that your Lordship has invited me to address. So, yeah, I think really probably, unless there are other specific issues that the court would like me to deal with so far as species 1 is concerned, that's probably as far as I can take it, bearing in mind that the court has already read and no doubt digested the voluminous written submissions.
Just check, my Lord. Read it? No? Yes.
Thank you.
If you want to deal briefly with species 2 then?
Species 2 can be dealt with very, very quickly. Both in oral submissions this morning and at paragraph 67 of the grounds of appeal, page 22 of the applicant's consolidated bundle, in quoting Norman, the applicant recognises that there is a balancing exercise to be performed here, and that each case is fact-specific. In the context of a remedy of last resort, and the clarification recently provided by a different constitution of this court in the case of Ng, the concession made in argument before Mr. Justice Goss, we submit, is fatal. But even if that wasn't right, and by that I'm referring to the fact that on behalf of the applicant, it was conceded that there was no misconduct on behalf of either the prosecution or police. But also this morning, and indeed also in the written application at paragraph 119, the decision for the trial judge is characterized as being a fine balance. Now, in dealing with that issue this morning, my learned friend has submitted to the court that even though it was a fine balance, the learned trial judge came down on the wrong side of the balance. But that doesn't, with the greatest of respect, deal with the problem from the applicant's point of view. And in this respect, I remind the court of the words of the Supreme Court in the case of Maxwell, when the Supreme Court was dealing with the issue of whether or not a retrial should have been ordered, in the face of what was truly remarkable and egregious misconduct by West Yorkshire Police. And one of the points made by the Supreme Court was that a differently constituted Court of Appeal might have come down against ordering a retrial. And indeed, their lordships in the Supreme Court were split 3-2 on the issue, with one, I can't now remember which of their lordships it was, but one of their lordships apparently, during the course of argument, changed his mind, having been persuaded by Lord Dyson. In order to succeed on species 2, given that it is an exercise of judgment by the learned trial judge, we submit that the applicant would have to persuade this court that the learned trial judge was demonstrably wrong. And to make that submission in the context of a concession that it was a finely balanced judgment, the 2 points of view simply can't be put together, or if one accepts it's a finely balanced decision, one can't say it's clearly wrong to come down on one or other side of the fence. So for those reasons, we would respectfully submit that species 2 doesn't get off the ground. But whether or not we're right about that, there is a third answer to the submission, which is that what was said, and this is coming back to my Lord's question earlier, what was said by the police and or the CPS representative at court pales into insignificance in the context of the facts that had been proved against the applicant in the trial, in trial 1, which convictions were admissible in trial 2 and therefore known to the jury in any event. And so, my Lord, for those 3 reasons, we would respectfully submit that species 2 doesn't begin to get off the ground. Unless there's any clarification or further elucidation.
No, thank you very much indeed, Mr. Johnson.
I'm being prompted from behind. And there is a very good point of which I'm reminded, and it's just going back to your Lordship's question, and species 1, a point that I overlooked, which is that's spoken of in many of the authorities about the corrective process of the corrective effect of the trial process. And of course, this court has seen that this jury was asked questions, and specifically when the application to stay was refused, the jury was asked 2 supplemental questions which appear in the Learned Friends bundle at tab 18.
Can you give me a page number?
I can, of course. It is page 350.
Yes.
So, unless that further submission has provoked any questions from the court, I think that's all I can reasonably say.
Not from me. No, thank you very much indeed. Yes, Mr. Miles.
My Lord, just 4 points I'd like to raise in response. The first is the submission that in some way, by using words like vitriolic or unadulterated, that is to mischaracterize the material that we look at. And also that there has been no objective analysis of that material. which in some way undermines the point we make. The court will form its own view of the nature of the coverage. What we have provided are examples. The summary provided by the respondent navigates its way through those examples without reference to evil, devious, cold-blooded, and the like, which are throughout. Context is important. My Lord, the court has been provided with the summary, but it's the underlying material that matters. It isn't good enough to say, for example, with regard to item 51, that there's reference to inside Lucy Letby's beige home, and that's an end of the matter. If one actually goes to the link, one finds it opens with, the former NHS nurse bought the ordinary 3-bedroom property in Chester, gives the price, and lived there whilst carrying out her cold-blooded, evil crimes. And then goes on to say, killer nurse Lucy Letby is set to die behind bars after being convicted of murdering 7 babies and trying to kill 6, meaning she'll never return to the place she called home, and goes on to describe the house where she carried out her campaign of terror. And if one goes to the underlying material, the inextricable binding of what may appear to be anodyne facts with comment that is properly characterised as vitriolic is there. So, for the assistance of the court, my Lord, we're compelled to observe it is important not simply to look at the summary, which necessarily is brief, but as we understand the court will have done, having the material, to have considered what underlies it, and it is deeply hostile. The New Yorker article, which is the one item that stands out in isolation, the significance of that is the reference it makes to the behaviour of the police and the programme they wish to engage in, publicising their work on the case. The court will form its view. The criticism that there's been no objective analysis of this, we respectfully do not understand as in terms of what we are meant to analyse beyond putting before this court the material that there is. The words such as evil, devious, cold-blooded or manipulative, coming not just from the reports but also from officers, speak for themselves. And we do not regard any further analysis as necessary. The question for the court, and ultimately would be a subjective one, is what unfairness follows from that. There's no cognitive breakdown we can do beyond looking at those words and a court, as courts do, assessing what the impact of them is. That's the first point. The second matter is this, that insofar as the convictions being admissible is an answer to complaints of unfairness, just add this, of course, that's not accepted by the applicant, but that would be no answer to species 2 in any event, which is a different issue altogether. With regard to species 2, the third point is this, my Lord. The respondent was asked to identify what was said about the comments by the police and the prosecution, and the answer was that it was largely measured comments, not prejudicial to the appellant in a retrial, and the jury would be unlikely to remember it 9 months later. We took the court, in summary, to comments from the police and the prosecution. We don't repeat it now. They're not measured. But the answer that it's unlikely a juror would remember them 9 months later, if that's correct in terms of the fade factor, may be capable of being an answer to species 1, but it is not an answer to species 2, which is the matter that your lordship was raising. That isn't the point. That's the difference. And as for the suggestion that the fade factor would mean that material at the time would not be carried in a potential juror's head, the point is that what will remain are words like evil or misconduct or killer or 4,000 cases. It can't be said, and there's no objective analysis to suggest they would not remain in a potential juror's mind. The final point we raise in answer to matters dealt with in the submissions, my Lord, is the question of the term fine balance, and whether that therefore shuts the applicant out from arguing that that fine balance was resolved in the wrong way. We submit that our recognition that there is a fine balance in this situation is no bar to the ultimate decision being wrong, because in our respectful submission, this isn't one of those cases where there is a broad discretion within which a judge may fall anywhere along a continuum. If it is unfair, and if this court finds that that offends justice and propriety, then that is an end to the matter. The fact the balance may be fine does not justify it if the learned judge resolved the matters in a way with which this court properly disagrees. And we respectfully submit that, fine as the balance was, those comments and that behaviour in the context of this case does offend in the way identified by species 2. And there is no broad discretion to be applied, which undermines our submission by our recognition realistically that these things may be difficult and there is a fine balance. I'm grateful for the opportunity to deal with those, my Lord. May I just be given one moment to confirm if there's anything further? Well, my lords, my lady, unless I could be of any further assistance, those are the submissions we make.
Thank you very much indeed. Mr. Johnson, we propose to give judgment today. There are orders preserving the anonymity of, self-evidently, the victims of attempted murders, including the baby who's the subject of this case. Is there any reason why this judgment and the outcome of this appeal application can't be reported in the normal way?
There's no reason at all, my Lord.
No. I mean, the previous judgment was only released, that is, in relation to the original convictions after the retrial.
Yes.
But that was the only reason it was delayed.
It was, my Lord. I'm sure that you, my Lord, knows this anyway, but the cipher given to the child in this case is baby K.
Yes. And this is absolutely no disrespect to that baby and to the parents. Because of the nature of this case, we shall make only but passing reference to the crime.
Of course.
Yes.
That's understood.
Right. Well, we shall rise to consider the position. I hope that we'll be able to give judgment before lunch. It obviously won't be for at least 15 minutes, but if you will make sure that you're available before lunch. Thank you.
Rise.
The judgment we're about to deliver will be available in written form as soon as possible after the judgment has been delivered, and it will be posted on the National Archive at some point later today. So those who are seeking desperately to make a note can relax a little. I shall say right at the start that we're going to refuse this application for leave to appeal so that the applicant knows the position, as do all those others interested in the case. Lucy Letby was a qualified nurse. She worked at the neonatal unit in the Countess of Chester Hospital. In August 2023, she was convicted in the Crown Court at Manchester after a trial lasting over 10 months, of 7 counts of murder and 7 counts of attempted murder. Her victims were very young babies being cared for at the unit. On 21 August 2023, life imprisonment was imposed on each count, and a whole life order was made in each case. The jury were unable to agree in relation to 6 other counts of attempted murder. They acquitted Letby of 2 counts of attempted murder. These counts also involved very young babies in her care. In relation to the counts on which the jury were unable to reach verdicts, the prosecution took time to consider whether to seek a retrial. On 25 September 2023, the prosecution announced at a hearing in Manchester that they proposed to retry Letby on 1 count of attempted murder. The trial was fixed for 10 June 2024. The trial judge, Mr. Justice Goss, imposed a reporting restriction pursuant to Section 4.2 of the Contempt of Court Act 1981, whereby there was to be no reporting of any matter which would create a substantial risk of prejudice in relation to the trial due to commence on 10 June. The background of the case to the case of Lucy Letby is very well known. It was set out in detail in a judgment of this court handed down on 2 July 2024 in relation to her unsuccessful application for leave to appeal against the convictions in August 2023. Neutral citation 2024 EWCA Crim 748. Her case attracted very substantial publicity as the trial progressed. After she was convicted, there was a great deal of broadcast and other media comment about the horrific nature of her offending. Doubtless this was the trigger for the reporting restriction imposed on 25 September. On the first day of her retrial, on 10 June 2024, counsel for Letby, who had represented her at the first trial, applied to the trial judge for a stay of the indictment, charging a single count of attempted murder. It was submitted that a trial on that indictment would be an abuse of process. It was argued both that Letby could not receive a fair trial and that it would not be fair for her to be tried. The argument was based on the nature and extent of the publicity arising from the first trial. Mr. Justice Goss refused to stay the indictment. The trial proceeded. On 2 July, Letby was convicted of attempted murder. On 5 July, she was sentenced to a further term of life imprisonment with a whole life order. Letby now applies for leave to appeal against her conviction in July 2024. The sole ground of appeal is that the judge erred in refusing to stay the proceedings. She's represented today by leading and junior counsel who have been instructed by her throughout. It is necessary to say at the outset what this application does not concern. Since the convictions in August 2023, there has been significant media coverage of the basis for those convictions. This has involved a critique of the medical and scientific evidence called at the first trial. Some of the public comment has called into question whether Letby ought to have been convicted in August 2023. We are not concerned with the first trial. That was the subject matter of this court's judgment in July 2024. Whether there are or may be issues arising from the first trial which have yet to be the subject of judicial consideration is not for us to say. That would be speculative. This application will not involve any detailed analysis of the evidence called either at the first trial or the retrial. Our concern is solely whether the trial judge was wrong to rule that Letby could not receive a fair trial in June 2024 and that it would be fair to try her. And this will involve principally discussion of the publicity given to her case. The basis upon which a judge in the Crown Court will stay proceedings as an abuse of the criminal process is very well settled. The principles and the authorities establishing them were reviewed comprehensively by this court in BKR, reported at 2024 One Weekly Law Reports 1327, neutral citation 2023 EWCA Crim 903 at 34 to 50. The core principles were again helpfully summarised in NUG 2024 EWCA Crim 493 at 21 to 25. We do not propose to repeat that exercise. The first type of case in which abuse of process may be established is where an accused could not receive a fair trial. In this instance, the argument is that the media coverage of Letby's convictions, reflecting in emotive language the nature of the offences and the revulsion at the underlying behaviour was so great and sustained that no jury would be able to give the issues in the retrial fair consideration. It was described to us as a campaign. The extent of the coverage and the notoriety of the case were such that there could be no prospect of any juror's memory of the coverage having faded. No direction given by the trial judge could remedy the position. The second type of abuse arises when it would offend the integrity of the criminal justice system for a trial to proceed. Where that type of abuse is alleged, any prejudice to the accused has to be balanced against the public interest in trying serious criminal offences. In this case, the submission is that following the convictions in August 2023 and before the making of the reporting restriction on 25 September 2023, police officers and representatives of the Crown Prosecution Service engaged in sustained hostile commentary about Letby's offending. There was reference to further investigation into her activity at the Countess of Chester Hospital, suggesting that her criminality went far beyond the offending represented by her convictions. It's argued that the police and the CPS knew that a retrial was at least a possibility. In those circumstances, it was completely unacceptable for them to engage in public discourse in the way that they did. The behaviour by those involved in the prosecution process offended the integrity of the criminal justice system so as to require a stay of the proceedings. These submissions were made to Mr. Justice Goss. In a written ruling, having accurately set out the principles to be applied, he dealt with the outcome as follows, quote, "I am satisfied that any prejudice to the defendant from the publicity in the media is not such as to preclude the defendant from having a fair trial. The evidence of her convictions will be in evidence before the jury. It will be subject to the necessary directions to the jury as to the use to which they may and may not put this evidence. They will also receive a direction as to the importance of reaching a verdict on and only on the evidence placed before them and nothing else. Experience has shown that juries can be relied upon faithfully to follow such directions. The media coverage will, in any event, have been diluted by the, quote, fade factor, unquote, since the verdicts in the original trial were reported. In relation to the second limb of abuse justifying a stay, even applying a broad interpretation of misconduct, none of the matters raised by the defence, individually or collectively, amounts to misconduct. Even if any do, it does not justify the remedy of last resort of a stay on the grounds of abuse of process when weighing the public interest in ensuring those charged with crimes should be tried against the competing interest of maintaining confidence in and the integrity of the criminal justice system. Unfairness to the defendant is not required to this limb. The focus is on whether a stay is appropriate in order to safeguard the integrity of the criminal justice system. The matters raised by the defence can be addressed and accommodated by the trial process, including any suggestion of malpractice or financial or other motives for untruthfulness on the part of any witness. The accounts witnesses have given of events at any time are all matters of record and available to be adduced and challenged in the trial process. The fairness of the trial is not compromised, nor could the court's sense of justice and propriety be offended, or public confidence in the criminal justice system be undermined by the trial proceeding," unquote. This was an exercise of judgment by the judge. Thus, we must assess whether his decision was wrong. This is to be contrasted with the exercise of a discretion, where we would be considering whether the decision was one open to a reasonable judge. Having said that, we must give substantial weight to the fact that Mr. Justice Goss had been the judge throughout the proceedings. He had conducted the first trial. He was fully aware of the factual nature of the case to be put to the jury in the retrial, and to that we must add the fact that his experience as a criminal judge is unrivalled. It follows that his judgment must be afforded very considerable respect. As is apparent from the judgment handed down by this court on 2 July 2024, the first trial involved a wealth of scientific and medical evidence from an array of expert witnesses. In relation to the counts of which Letby was convicted in August 2023, the evidence was circumstantial. Some of the evidence related to Letby herself. Reliance was placed on the following matters: her ubiquitous presence when babies died or suffered collapse, creating false entries on documents with the apparent intention of concealing her unlawful activity, taking home handover documents apparently connected to the babies who had died or collapsed, searching Facebook for the families of babies who had died, making statements in private notebooks consistent with guilt. A great deal of expert evidence was called. Various causes of death or intended death were identified. Air embolus, caused by air being injected into the vasculature via intravenous lines. Air forced down a nasogastric tube. Insulin poisoning. Overfeeding with milk. Trauma. These alleged causes of death were the subject of expert evidence. This evidence was challenged in the course of the trial, particularly in relation to the proposition that babies had died because of an air embolism caused by deliberate injection of air. Letby herself gave evidence denying any unlawful act towards any baby in her care. The case against Letby, which was tried in June and July 2024, did not rely on expert evidence to demonstrate the unlawful act carried out by her. Rather, the prosecution relied on the evidence of a Dr. Jayaram, a consultant paediatrician who worked at the neonatal unit. The baby who was the subject of the trial was extremely premature and had been intubated on her arrival on the unit. Shortly afterwards, Dr. Jayaram came to the area where the baby was being cared for to find Letby by the baby's cot. The monitor showed that the baby had a dangerously low blood oxygen level, desaturation. Letby was doing nothing to assist the baby, whether by administering oxygen or calling for assistance. The cause of the desaturation was that the endotracheal tube had been dislodged. The prosecution case largely depended upon the jury accepting the evidence of Dr. Jayaram. His evidence was the subject of significant challenge, the suggestion being that his account of Letby's acts and omissions was wrong. Mr. Justice Goss was provided with a very substantial body of digital material showing the level of publicity. The defence compiled a schedule of media content intended to give examples of the kind of coverage there had been. The schedule contained links to particular online articles or reports. Of the 64 entries on the schedule, 59 related to coverage in the days following the final verdict of the jury in August 2023. Most of the coverage was close to the date of the verdict, although it did continue sporadically until 25 September 2023. We have read all of that material. In written submissions, Mr. Myers, King's Counsel, and Ms. Clancy have emphasised the following. Daily Mail podcasts in August and September 2023, including discussion with the police officer in charge of the investigation, and a police officer who interviewed Letby. The former referred to Letby being able to manipulate others at the unit so she was able to get away with murder. The latter spoke of Letby being one of the worst murderers of modern times. A Talk TV recording of an interview with one of the main prosecution witnesses, expert witnesses, in which he said that what Letby had done was beyond belief. Similar posts by Channel 4 News and Sky News. Reports in more than one media outlet that the police were investigating further possible cases of the death of babies being caused by Letby. The reports referred to the police looking into 4,000 admissions of babies into the unit. BBC Panorama documentary with interviews with parents, police officers and a doctor from the hospital. Newspaper and online references to Letby making comparisons with Myra Hindley and Rose West and describing her as evil. Adverse comments by leading politicians, including Rishi Sunak, the then Prime Minister, about Letby's failure to attend her sentencing hearing. The submission to Mr. Justice Goss, and repeated to us, was that the reporting of the trial, and more particularly its aftermath, was emotive. Although the factual presentation of the offending as found by the jury was accurate, its effect was overwhelming and prejudicial. To use the language of the written submission, the vitriolic nature of public comment and the prejudicial matters reported created exceptional prejudice. Because the prejudice created was based on a trial which had already taken place, it could not be ameliorated by directing the jury to concentrate on the issues in the trial. Given the quantity of adverse material, there could not be any fading from memory of what had appeared online, in the press and on television. We do not accept the applicant's argument. The outcome of the first trial undoubtedly led to an unusually large amount of publicity and online debate. That is because, on its facts, the case was extraordinary. Simply because the extent of the publicity was much greater than would normally be the case, of itself did not generate prejudice. For a neonatal nurse to murder 7 babies in her care was a startling fact. Even if no police officer or other commentator had said anything about Letby being comparable to other notorious murderers, or used extreme adjectives to describe her, the mere fact of her offending would have created that effect. In relation to the more emotive language used, the fade factor would be significant. From 25 September 2023 onwards, the reporting had been limited. What would remain in jurors' minds would be the fact of Letby's offending. That fact was before the jury as evidence in the case. The judge directed the jury about the previous convictions in these terms. If you are sure that the defendant's convictions show that she has such a tendency to commit offences of this type, then this may support the prosecution that she attempted to murder the baby. It's for you to say whether it does, and if so, to what extent. But you must not convict her wholly or mainly because of those convictions. The fact that she's been convicted of the offences in the past does not prove that she committed this offence on this occasion. Previous convictions may only be used as some support for the prosecution case if, having assessed the evidence, you're satisfied that it is right to do so. In those circumstances, we conclude that the judge was right to find that Letby would be able to have a fair trial. We take into account the fact that almost all of the material of which complaint now is made emerged in the week immediately following conviction. The prosecution relied on what they termed the fade factor. We consider that they were right to do so. In our judgment, it is of some significance that the critical issue for the jury was whether they were sure of the evidence of Dr. Jairam. Legitimate criticism could be made of his evidence. Although he believed that Letby had deliberately dislodged the endotracheal tube, he had said nothing at the time, nor for many months after. There was an inconsistency between his evidence and the contemporaneous records. The nature of the case being considered by the jury was fact-specific. Had the jury known nothing of the outcome of the previous trial, the publicity surrounding it would have been a significant factor. Since the convictions were in evidence, the publicity was of far less effect. The prejudice came from the jury knowing that Letby had been convicted of 14 offences of murder and attempted murder. That prejudice, as a matter of law, was outweighed by the probative value of the convictions. Had it been otherwise, those convictions would not have been admitted in evidence. Before leaving the issue of whether Letby was able to have a fair trial, we must deal more particularly with the position of Dr. Jairam. Mr. Myers and Miss Clancy argued that his position was especially problematic. He had given evidence in the first trial when the jury had disagreed on the count where his evidence was critical. Following Letby's convictions, he'd been interviewed by a variety of outlets and had commented on social media about the case. The schedule of material relating specifically to him indicates that he ceased to comment once it was known there was to be a retrial in relation to the count with which he was particularly concerned. But the submission is that his public statements prior to that were, quote, extraordinary, unquote, given his position as a witness. We do not agree with that proposition. We have reviewed the material relating to Dr. Jairam with care. We could not identify any matter relating to Letby which significantly departed from or added to the evidence he gave in the two trials. He made comments about the extent to which those with overall charge of the neonatal unit bore responsibility for what had occurred. That could not have prejudiced the case against Letby. In the course of the retrial, Dr. Jairam was cross-examined about what he had said in one interview given after the first trial. This was not in order to criticise the fact that he had been interviewed. Rather, the content was used to make a forensic point on behalf of Letby as to what the witness had said previously about her actions. The argument in respect of the second type of abuse is that the police and the Crown Prosecution Service made comments after the verdicts in August 2023 which were unacceptable and inexcusable. In the course of the argument before Mr. Justice Goss, Mr. Myers accepted that those comments were not made in bad faith, nor did they amount to misconduct. Mr. Myers categorised them as, quote, ill-judged, unquote. Nonetheless, he argued then, as he does now, that what the prosecution and the police said meant that the trial would, and in the event did, offend the integrity of the criminal justice system. Police or prosecutorial misconduct is generally recognised as the first requirement in any finding of this species of abuse. The cases cited at 35 to 43 of BKR confirm this. We accept that misconduct in the conventional sense is not the only basis for concluding that it would not be fair to try a defendant. That is clear from the citation of Norman, 2016 EWCA Crim 1564 in BKR. However, for criminal proceedings which would be fair to the accused to be stayed, something very much out of the ordinary must have occurred. Mr. Myers said that the police had embarked on a media campaign in emotionally charged circumstances. We consider that this is an overstated description of what the police officers did. The trial of Lucy Letby was a matter of national public interest. Once the trial had concluded, there was an inevitable demand on those with a close knowledge of the case to speak to the media. What was said by police officers was not wholly restrained. They described the offending as horrifying and the person responsible as evil. But they did so after a jury had found that Letby had murdered 7 babies. The notion that after a substantial criminal trial, police officers involved in the investigation should not speak with a degree of freedom to the media is fanciful. If a person is convicted of multiple offences of the kind with which we're concerned, what the police say about the person is bound to be hostile. It could hardly be otherwise. It does not make the comments of the police akin to misconduct. It's said that this case was different because there was at least the prospect of a retrial. This did not materially affect the position. Letby had been convicted of 7 counts of murder and 7 counts of attempted murder. She was sentenced for those offences. The trial judge did not impose any restriction on reporting of the sentencing exercise. Nothing said by the police officers went beyond what would have been apparent to the jury as soon as they were told of the nature and extent of the other offending. Reporting of the outcome of the first trial included material relating to continuing investigation by the police. It was reported as follows, quote, "Police are now investigating 4,000 admissions made into neonatal units at the Countess of Chester Hospital and the Liverpool Women's Hospital, where Letby spent time training between 2012 and 2016. The probe is a continuation of Operation Hummingbird, the investigation into the deaths and non-fatal collapses at the Countess of Chester Hospital. Detective Superintendent Paul Hughes, who led the investigation, said, 'This does not mean we are investigating all 4,000. It just means we are committed to a thorough review of every admission from a medical perspective to ensure that nothing is missed throughout the entirety of her employment as a nurse.' In written submissions, Mr. Myers and Ms. Clancy said that the remarks of the police officer, quote, were, quote, lamentable, unquote. We disagree. The officer said that in the light of the findings of the jury, it was appropriate to review the entirety of Letby's career as a nurse. That was an unexceptional comment. The figure referred to was simply the number of babies who had passed through the relevant units during the relevant time. The police officer cannot be criticised if journalistic hyperbole therefore created a false impression. The judge identified that to stay a criminal trial, because it would offend the integrity of the justice system, always will be the remedy of last resort. It is an exceptional step to take. It was not justified by the circumstances in this case. The judge was entirely correct to find that it would not be unfair to try Lucy Letby for the single offence of attempted murder. It follows that we refuse her application for leave to appeal against conviction. We repeat what we said earlier. This application related to a narrow legal issue. Nothing we have said can contribute to any debate about the wider case against Lucy Letby. Mr. Myers, Mr. Johnson, thank you both very much for your very helpful written submissions, and to your juniors and to those others who support you. We were greatly assisted. Thank you. Thank you very much.